The other aspect I want to just talk a little bit today about is watching my time, because everyone is an expert, is the whole question of costs and estates, and the theory of costs when someone does get into a litigation environment. It used to be, and I blame my father for letting this perk vanish in my generation, but it used to be in his days, in his early days of practice, you came up, you stood up in front of a judge and you said, if there's a dispute here, who cares, no blame, let's take all the money out of the estate, pay all our costs at our full rate. And over the past 30 years, that's changed fairly dramatically, and now it's a very regular occurrence that the loser pays. So if you take a position that, for example, that the will isn't valid, or that in the joint account scenario that the asset should go into the estate as opposed to into the hands of Betty on the death of the individual, and you lose, the courts are very, very aggressive about who pays those costs. So it brings an added layer of risk to an executor, because an executor is sitting there saying, I don't know, I wasn't around, and am I supposed to instigate litigation to find out that answer and risk someone someday down the road saying the costs are now your problem? That joint account was clearly, the judge finds it was clearly not an estate asset, and now that executor sits around and turns around to his lawyer and says, what do we do about costs? And the judge says, well, actually, you shouldn't have brought this forward. You lost. You pay the costs. So that kind of risk is very different than it was even 10 years ago in terms of that. And the courts are really turning to be a more commercial court in that sense, and a much more draconian court in that regard. So it's just another element, another factor that I really make sure my clients understand and that we manage when we're taking on the job of an executor. You know, another element of the executor's job is that you can actually go to the court and ask for advice and direction. You can say, look, I don't know what to do here. How am I supposed to know which beneficiary? Should the income beneficiary get 20% or 2%? And should I be eating into capital and so forth? And the courts will sometimes, in the right circumstances, answer that question. 20 years ago, they always answered it, and they took the costs out of the estate. So those days are gone, and it's something that adds to the whole question of it.